Welcome, I'm John. Some of y'all know me, some of y'all may not. For those of y'all who don't know me, I'm John Ross. I started the Ross and Schollmeyer law firm with Lisa Schollmeyer about 15 years ago here in Texarkana. She and I, 2 laptops and a card table. Today we're the largest elder law firm in the Southwest. Offices in Texarkana, Longview, Tyler. We serve Dallas to Little Rock. 20 staff people, 7 of them lawyers, and off we go. And all of that because we recognized that there was a group of folks out there that had 3 concerns. They really wanted to try to avoid long-term care if they possibly could. They wanted to avoid becoming a burden on their family if they could. And they wanted to avoid going broke trying to accomplish the first 2 goals. And we knew that there was possibilities out there, and with our background being both accountant lawyers, we knew that we could untangle the government mess in all of this between Medicare, Medicaid, Social Security, veterans benefits, combined with our knowledge of tax law, and put all that together, and we could figure out paths and do all of this. And basically what it all boils down to is asset protection. And where people screw this up is they plan basically for what they hope happens, right? Anybody who's ever done any estate planning, if anybody in here, some of y'all are certainly too young to have ever done anything, but 75% of all people that die with no estate planning whatsoever. And even of the 25% that do, wasted their time and effort. Because here's what it says: I leave everything to you, you leave everything to me, and when we both die, we leave everything to the kids in equal shares. That's what I call the I love you plan. Right? And that's all fine and dandy, except that what it doesn't do is it doesn't anticipate anything going wrong. And that's where the real benefit of being able to know all these rules and be able to plan through it comes in. And we can break down the things that are likely to go wrong into what I call the 4 Ds. Right? So we'll go through them. Number 1, death. You're going to die. It's going to happen. The problem is that people have a tendency in their mind to think of that in some sort of order, right? Like, my parents are going to die, and then later I'll die, and then later on my kids will die, and so on and so forth, in some particular order. The problem is that doesn't always happen, right? So when I'm talking to that husband and wife, and they're saying, yeah, we want to leave everything to the 3 kids, well, that's all fine and dandy, unless one of them's dead. Now where's it go? Does it go to that kid's spouse? Does it go to their kids? If it's going to go to the grandkids, how old are those grandkids? Are they 8? Because if you leave money to an 8-year-old, you didn't leave it to the 8-year-old. You left it to the 8-year-old's surviving parent who brought their next wife to the funeral along with their 3 kids, right? And what you left behind for your grandchildren starts looking a whole lot like what you left behind for your dead daughter's child's former husband's new wife's 3 kids, which is probably not what you were planning. Right? So you want to be able to say, okay, look, here's who I'm going to leave stuff to, but if I'm leaving it to this person and they've predeceased me, then here's who it goes to. And if it lands in the hands of somebody who's under some particular age, right? Minimum would be 18, but I have 18-year-olds. They're stupid. Right? So you know, maybe I need to back that up a little bit. Maybe it needs to be 21 or 25 or even 30. Really, beyond 30, there's not much point, because if you hadn't gotten any sense by 30, you're never gonna. And having somebody that I trust to be in charge of that, right? So if I'm leaving it to the 8-year-old, well then here's who I want to be in charge of it for that 18-year-old, you know, and that could be a trusted family member, it could be Farmers Bank, it could be whatever, right? So you've identified somebody that's in charge of it. So the whole point here is that we're not just assuming that everybody's gonna be around. You need to think down through that a little bit. I actually got a call from an old family friend, so one of my old high school buddies. It was his parents. And they were about to take all of their son, who's the only child, and his 2 kids, both in their teens, and they were taking them all to Peru. And his question was, what if the whole plane goes down? Well, at least he was thinking about it, right? And so, even beyond that, you might think about what I like to call the plane crash clause, right? You take the whole family on a Malaysian Airlines trip across the South China Sea, which has not historically worked out great for people. Right? So, among other things, like, I'm the president of the Alzheimer's Alliance, and Lisa Scholmeyer is the president of Opportunities, or the incoming president of Opportunities. And so, in our plan, if everybody's dead, well, then we'll just split everything between the two charities. Or maybe you've got distant family members that you want to include or something. But again, you're just looking down that line and saying, okay, but what if they ain't there? Simple enough, right? So that's death. The second one is divorce, right? If I'm leaving something to my child and, my daughter's husband's run off with the pool boy, but that's fine, he can do what he wants, but he ain't taking my stuff, right? I intended that for my daughter. And some people have heard a little bit about this, and they'll say, oh, well, yeah, but John, I understand that inherited property is separate property. Well, that's actually true. If you've heard that, you're a little step above everybody, right? In Texas is a community property state. And everything a married couple has is community property except for three things. Property that you had before you got married, property that's acquired by personal injury, right? So if you get in a car wreck and you sue somebody and you get some money out of it, that's your separate money. Party like a rock star. And then the third thing is property acquired by gift or inheritance, right? So if I die and I leave my child my house, for example, that's her separate property. But what's going to be required for that house almost instantly? Taxes, insurance, upkeep, maintenance. What are they going to pay for those things with? Community property.
Oh, now we got a problem.
And now we got a problem, right? Because on day one, yes, it is definitely separate property, but on day two, it's mostly separate property. And a little bit community property. And so, maybe if it's just a small estate or no big deal, but a lot of times I've got clients that've got family land, it's been in the family for generations. I actually had a lady come in from DCAB a while back, and she wanted to transfer her 40 acres to her grandson, and she was 92 years old. And I told her, I said, well, yeah, come in, we'll talk about it, and while you're at it, bring me the deed. I'll need to take a look at that. And so she came in, and I said, did you bring the deed? And she said, yeah, but it's actually not in my name. It's in my grandfather's name. Now, this lady's 92. Right, so she pulls out the deed, and it's this crumply little yellow, you touch it, it turns to powder, and I literally open it up, and it says something to the effect of, by order of the President Abraham Lincoln, as a newly freedman, here's your 40 acres. It was an original land grant. Post-Civil War freed slave. I said, well, first, take this to the museum. And then second, we're going to need to try to protect this land, right? Because, again, if you've got that kind of lineage with your property, you're going to want to protect it from an errant spouse out there. So, all of that to say, divorce. So we got death, we got divorce. The next one is debt. Debt can come in a lot of forms. I just 2 days ago dropped my 18-year-old off at Texas A&M University in College Station, where she is starting Hell Week with the Corps of Cadets. She followed in her daddy's footsteps and has joined a Marine Corps unit. Her life sucks.
You're enjoying that, Jim.
I am enjoying it a lot, yes. It's fantastic. But for most people, college ain't cheap. Now, I can do a whole other program on how you can manipulate the FAFSA. So if anybody has any questions, I can tell you all about that. So my child actually got a $3,000 refund. So they're paying her to go to Texas A&M. It's because I know the rules. But for most people, they don't know the rules, and so they just go in thinking they got to pay $12,000 a semester, which is what it would have been. And that's a fast way to rack up some student debt. In the United States, there are 106 individuals with over $1 million in unpaid student loans. How in the heck do you get to $1 million, right? But it's not uncommon for people to have hundreds of thousands. That's actually very, very common. Most of them cannot make those payments. An unpaid student loan has the same collection power as the IRS. Right? So if you think the IRS can come and get your stuff if you don't pay the tax man, you're right. But so can an unpaid student loan with the exact same authority. So whether it's, and I've got another estate right now, guy just died, got 6 kids. One of the 6 kids filed bankruptcy 3 days before dad died. Guess where his 1/6 of the estate's going? Right? Straight to the bankruptcy court where they can liquidate it all and use it to pay off his creditors. Right? So there's lots of ways that debts can come out there. And again, if you're talking about leaving assets for yourself, or even if you're talking about your own personal assets, there are ways to shield assets from third-party liabilities. With a little bit of planning, I could leave you money, right? What's your name? Jennifer. I could leave Jennifer money, right? And I could leave it to Jennifer in such a way that she could do with it whatever she wants, despite the fact that she ain't paying her taxes, she's not paying child support like she's supposed to, she's not paying her student loans like she's supposed to, and she's in the middle of a bankruptcy, and ain't none of them getting it. Right? Again, knowledge of the rules, right? So it's very easy to build in some asset protection when it comes to third-party creditors. That brings me up to the last one, which is which is disability. So death, divorce, debts. Last one is disability, and this is the big one. For most people, when you start looking at going through retirement, right now the current estimate is that if you're turning 65 right now and retiring, that you need approximately $250,000 in liquid cash to cover your unreimbursed medical expenses through retirement. And that's even with your Medicare and your supplemental insurance. That's a bunch of money, right? And so, if I get in a car wreck this afternoon and I've got a catastrophic brain injury, if I want to stay home, well, my insurance is not paying for somebody to sit around the house with me all day long. That's going to cost me $15 an hour. 24 hours a day, it's $300 a day. It's $9,000 a month. Middle ground assisted living in Texarkana, which is a relatively inexpensive area, $3,500, $4,000. Your nursing homes run you about $160, $170 a day. It's about $5,500 a month. And you figure that if you're female, your life expectancy in a long-term care about 3.5, 4 years. If you're a man, that's about 2.5 to 3 years. So you're talking 7, 8 years long-term care expenses at $60,000 a year for a husband and wife. How are you going to pay for it? Right? And so this is probably the biggest threat for most people. This is what we see, and this is what we've built our whole practice on. And it's because people do not understand these rules and how you're going to pay for it. There are ways out there. And just as an example, so Lisa Schulmeyer, she has a twin sister. Her twin sister's name is Leanne. Leanne was born with a brain injury. Leanne lives at Holy Angels in Shreveport, which is a super nice group home place. And Leanne's a lot of fun. She's 48 years old, but mentally she's probably 6-ish, 5, 6. So she likes to talk on the phone. We got her a cell phone a couple of years ago. It's just got 5 buttons on it. She pushes button 1, it calls me. She pushes button 2, it calls Lisa. She pushes those buttons. We've already replaced the phone once because she wore the numbers off. Right? She likes to go out to eat Mexican food. She likes new clothes. She wears an extra large t-shirt, which she will tell you about 800 times. And so she likes all these stuff, none of which is paid for by her SSI, her Medicaid, her government housing, her government food programs. That's like when I was in the Marines, right? They're like, John, what are you complaining about? You got 3 hots and a cot. Right? You got a place to sleep and you got food in your belly. What else do you need? Well, I need a lot. That's why I got out of the Marines. So none of that stuff, those programs don't pay for any of that. Well, their dad, Jimmy got diagnosed with terminal liver cancer at 68 years old, so he's a dead man walking. he's going to die, right? And throughout his life, it was always, well, Leanne, when she was born, well, she's never going to see 3. Well, and then she was 3 years old, and they were like, well, yeah, but she's never going to see 7. And then she was 7. And she'll never be a teenager until she was a teenager, right? So it was always, well, Leanne will die. But Leanne just continued to live a long, healthy, happy life, and now Jimmy's going to die. And Jimmy was the one making sure she had new clothes and all of that. So he would like to leave money to Leanne. But if he does leave that to Leanne, she would be immediately disqualified from the SSI, the Medicaid, the housing. She would be kicked out, homeless, with no income, no health insurance, no way to support herself. And as little as $759 could do that. Yeah, so pretty tight, right? And so preserving those government benefits and yet still providing her a quality of life is super important. So there's been a solution to this for years. It's something called a special needs trust. So the government rules will actually allow you to create a trust for Leanne's benefit and let Jimmy transfer an unlimited amount of assets into that, where all of that money can be used for her to provide her a quality of life, but none of it affects her eligibility for any government benefit. So he died, he left money to that trust, we still manage it for her. Her life continues on. But now look at my own planning, right? My stuff says if I die, I leave everything to the wife, right? She can bring her next husband to the funeral. Cool. The problem is that you start talking about long-term care, particularly within a husband and wife. Medicaid's the only program that'll pay directly for something like nursing home care or things like that. If you've got a husband and wife and one spouse needs Medicaid and one doesn't, I can get anybody qualified for Medicaid, just about. They'll let you shift assets between the spouses. So, if you got a house, car, and $500,000, and you got husband needs nursing home care and the wife's still at home, I can get them qualified for Medicaid. Let the state pay for it. That's for a married couple. If you're single and you're trying to qualify for Medicaid, you can have a house, a car, and $2,000. And when you die, they're going to try to take the house. That's broke. Now, so if I'm worried about what happens if, let's say, Lisa gets Alzheimer's disease, well, if she gets to a point where she needs long-term care, it's no big deal because I could essentially shift our assets over to me and get her qualified for Medicaid. Problem is, take something like Alzheimer's, right? Life expectancy of somebody with Alzheimer's, 10 to 15 years. Life expectancy of the spouse of somebody with Alzheimer's, 3. So hard being a caregiver for somebody with Alzheimer's, it kills the caregiver. Almost every time. Yeah. So, hey, no big deal, right? She gets long-term care, point, I can just shift assets over to me. Problem is, I'm doomed. So I'm going to die, right? And now going back to that little I love you plan, I leave everything to you. And now she's single. And I didn't really leave it to her. I just basically left it to get spent at $6,000 a month. But what if I go back to that same little tool, right? What if I said, well, I'll leave everything to Lisa, but if she's incapacitated, then I want it held in a special needs trust, just like we did with Leanne. We're driving down the road, we get into a car wreck, I'm dead, she walks away without a scratch, what's mine is hers. We get into a car wreck, I'm dead, she has a catastrophic brain injury, what's mine, now held in a special needs trust, would never count towards her eligibility for Medicaid. We both die, everything goes to our 4 teenagers. Unless one of them is incapacitated, in which case their share goes into a special needs trust for their benefit. And now I'm protecting against that disability, right? So death, divorce, debts, disability, these are the things that could happen that you don't want to, right? To be perfectly honest, if everything goes the way you want, right? I'm an only child, my parents have been married for 100 years, and they've lived in Texas their whole life, everything they have is community property, all their children are children of the marriage. My mom dies with no planning whatsoever, everything goes to my dad. Both my parents die, no planning whatsoever, everything goes to me, right? They didn't even need planning to get that result. So really the only benefit in doing this is for him, for them to say, yeah, when one of them dies, everything goes to the spouse unless the spouse is incapacitated, in which case it's protected for them. And then when they both die, everything goes to the kids. But If one of them's disabled, it's held in a special needs trust. If they're in bad marriages, it's shielded from divorce. If they have creditor problems, it's shielded from bankruptcies and other lawsuits and things like that. And here's what happens if they're dead. And now we've actually rounded out a pretty good little plan. We've protected from all those things so that when somebody comes back to me and says, hey, John, we've had a catastrophe. Yeah, you're good. That's the response I want to be able to give people. Not, well, I can fix it. Because if you're talking to a lawyer and they can fix it, it's going to be expensive. The cost of pre-planning is pales in comparison to the cost of trying to fix something that has already gone wrong. So, any questions about any of that stuff? Yes, ma'am.
Okay, this is a real live case.
All right.
My granddaughter's 18, and I have my estate planning with him. Best money I ever spent, and I'm tight with money, as everybody will know. But anyway, I would love for her to be able to drive our truck when she has a driver's license. My IRA is substantial. So we'll say $200,000. That's out of the trust. If she gets in a wreck and the car's in my husband's name, can they touch that IRA?
So a couple of things. So basically the question is, you've got an 18-year-old daughter thinking about maybe she's going to need some wheels, right? She needs something to drive. You're thinking about letting her drive y'all's truck. You're concerned she gets into a car wreck. What about your IRA? Texas, right?
Yes.
Yeah. In Texas, IRAs have an unlimited protection from things like lawsuits. So you're basically covered there anyway. Now, good auto liability insurance, possibly with an umbrella coverage for something like that, not a bad idea. I will say that with our kids, every time they turn 18, we put the car in their name. We get it out of our names and put it into their name. We understand that it's their car at that point and they could do with it whatever they want. Insurance costs more because of that. We're willing to pay for it because again, 4 teenagers, 3 car wrecks so far. Yeah, every one of them so far. The only one that hasn't is the youngest one. She's 16 and she's only been driving for 2 months. So,
See, that's what I was afraid of, but I was hoping that wasn't the answer because the old truck is more stable than the car we're going to give her. So when she had a wreck, it wouldn't be quite so bad.
right, yeah. So so your IRA is safe though. IRAs are generally protected from creditors, particularly in the state of Texas. Yes, ma'am.
Okay, real life situation in Texas. My mom's in a nursing home. My dad is in the community. His sister is about to pass away. She's in hospice care any day. He's going to inherit $30,000 from his sister. My mom's on Medicaid. That's his money, but they have no money. My parents have no money. He needs all kinds of work done on his house, and he's in pretty good shape physically. Mentally is going to be his issues. He's having memory problems. He'll probably be in the community. He's only 71. His sister lived to be 88. I expect him to be in the community for several years. So, but that was set up years ago that he was going to get this $30,000. And I'm concerned that, every year my mother has to renew her Medicaid.
Right. So mom and dad, mom's in the nursing home, dad's about to receive $30,000. So interesting thing. So with Medicaid, when you're applying for Medicaid for a husband and wife, they're treated as a married couple. Everything they have is theirs, right? The day after one of them have been declared eligible for Medicaid, they're treated as 2 separate people, right? So if I got the wife qualified for Medicaid today and tomorrow won the lottery and got $1 billion, she's still on Medicaid. Right? So the $30,000 received by the spouse will not affect her eligibility for Medicaid.
Even though she has to renew every year.
Even though she has to renew every year. He can actually, again, he could win the lottery and it would not affect her eligibility for Medicaid. Now, just don't expose that money to her, right? Don't go put it in the joint bank account.
Yeah, that's the first thing
It has to be kept separately. So yes, you'll definitely want to keep it in a separate account.
So what happens if you have two people, they're divorced, and they remarried, they have blood children on each side. The father has more than the mom. He leaves everything to her, and does the blood child get to come and contest everything to not go to the step?
So you're talking about, basically your question is, particularly in a blended situation, blended family, although I've seen it in good old-fashioned homogenous families where everything goes to the spouse, but the kids ain't happy about it. We see this a lot. In fact, we're starting to see it a lot more while the people are still alive. We get into they're just incapacitated and the fight starts. They're not even waiting until they die at this point. It's very difficult to protect. So the short answer is, if you've designed the planning correctly, it will make it very, very difficult to contest anything. Now, you can never prevent somebody from contesting anything, because all you got to do is have $287 and a way to the New Boston courthouse, right? And you can file anything you want. You might lose, but you can file anything you want. So you can never prevent somebody from contesting. But you can make it so it's very difficult, so that basically the financial incentive, they're just going to waste money pursuing it, and in the end up with nothing. So even if you're a blood relative. So the beauty of it is, at least in every state except Louisiana, every state in the United States except Louisiana, you can leave your stuff to whoever you want to and in whatever shares you want to, with no requirement that you leave anybody anything. This whole rumor about you got to leave them $10 or something like that, it's pure rumor. You can completely disinherit anybody you want, right? So you can leave everything to your spouse and completely not leave anything to your own children. So your question is, do you have to state that? It would be a good idea.
Like a long lost person that decides they're a relative.
Right. There's a
yes.
There's a law that's called the pretermitted child. There's a law for everything, right? So think of it this way, right? Let's say that I did some estate planning when I had 3 kids, and I said I leave everything to the 3 kids, then later had a 4th child but never changed the planning, right? So the planning says I leave everything to my 3 kids, even though there's 4. Well, the law says, well, since I only mentioned the 3 and didn't mention the 4, the law presumes I made a mistake, and that I would have included them had I known. And so they get to come in as if I had died with no planning. So if I have 4, but I just really don't want the one to get anything, right? So then it's important then for me to say, I got 4, but I don't like this one. So I ain't giving them squat, right? And be very clear about it and be very blunt about it. You don't want there to be any questions. You're just laying it out there. So yes, you definitely want to mention and then exclude if that's the plan. Yes, ma'am.
I got a 2-part question. So if you have what you consider to be an up-to-date plan, barring a change like a death or something, how often should you review with you that plan? Is it an annual review? And I guess to my part B is, what if there's changes in the law? Is your existing plan grandfathered the way it was written, or do you have to update to the new law?
So first question is, how often should you get things looked at, right? And my best analogy to this is, when was the last time you had a physical? To be perfectly honest, it's probably been a couple of years for me. I stay pretty healthy. I don't go to the doctor much. I try to eat right and stuff like that, so I don't get checked out all that often. But if you compare that, say, to my parents who are much older, they probably go at least every year just to kind of make sure and just get a look at, right? It's becoming a bit more. So there's no magic rule in all of that. Certainly anytime there's a major change in the family dynamics, right? If there's a sickness or a death or a change in the family structure, something, probably a good idea to at least have a phone call or something. So there's no magic number there, but occasionally. The folks that roll in and the last time they looked at it was 1972, that was probably too long. Your second question is about what about subsequent law changes? This is, and whether or not the stuff that you have done is grandfathered into whatever the law change is. And that's going to depend entirely on the law change. So for example, take the estate tax, the death tax, right? When I started practicing law, everything a person had when they died, if it was over $625,000 total value, then everything they had above that was going to be taxed at about 50%. Right? So if you had $1 million, 400,000 of that was going to get taxed at 50%. Somebody was going to owe the IRS 200 grand. Right? That was then. Today, you would have to have, for a single person, $11.2 million before you pay a dime in the estate tax. And for a married couple, that doubles to $22.4 million. Right? So if you had $1 million and in 2000, 1999, we had a conversation about this. There was probably some tax planning that was involved. May have overly complicated your planning to try to save you that $200,000. Most of that stuff probably irrelevant now if you still got $1 million because you were over it then. You're a long way away from it now.
Is that federal?
That's the federal, and there is no state level death tax in Texas, Arkansas, or pretty much anywhere around here. You got to get up to like Illinois and either the Yankees and the lefties over there. It's one or the other. For the rest of us, we don't really have to worry about state level death taxes. So that's an example of, well, the estate tax doesn't affect you until you're dead. Right? So whatever planning you have is going to be when you die. So if, for example, we got a new administration that cut the exemption back down to $600,000, well, if I'd have talked to you last year and said, you don't need any estate tax work because it's $22 million for you and your spouse, and then next year it's $600,000, well, we've changed. So it's hard to say there. That's something that wouldn't affect you till you died, and it'd be whatever the law is at your death. Whereas other things, the fact that, in Texas, in order to witness a will, you only have to be 14 years old. I don't know why that is. But if they changed the law and said, no, to do a will, you have to witness, witnesses have to be 18. If they changed that rule right now, but you did it while it was 14, you'd be fine. The will would still be valid. So it's going to be more that sort of thing. Very hard to say. That's a long answer to your relatively simple question. Anything else? All right. Well, listen, I appreciate it. A couple of little things. We publish the Aging Insight magazine, which is on your table. Feel free to take these. It's got some good articles on VA benefits, Medicaid benefits, powers of attorney, special needs trusts. Also in the back is essentially our resource guide of every senior service within about 100 miles of Texarkana. So every nursing home, home health, hospice, assisted living, they're all in the back of that. We do a live radio show on 98.7 FM every Saturday at noon called Aging Insight. You can check that out. It's also broadcast Facebook Live, where you can go on our Facebook page, check all of that out. If you have Cable One, we have a television show on there, also called Aging Insight, where we talk about all of this. And if you like podcasts, I'm the host of the Big Picture Retirement podcast, and we're in the top 100 on iTunes right now. 100,000 downloads and rolling. So if you want more on retirement, check out Big Picture Retirement. So appreciate y'all. Y'all have a good one.
Thank you.
Thank you.